back on the record, Judge.
Thank you, Jeffrey. Yeah. All right, counsel.
For Luba, Gonzalez, who's also present.
Okay, so what's the update here?
So I spoke with Luba Gonzalez, Your Honor, and I had no role in the preparation of the pretrial memo that she prepared, but I discussed with her the ramifications of proceeding today, and she would like to schedule this proceeding after the substantive decision in the case for reasons which I think are apparent given the nature of the kind of defense that she would like to raise. I would also like to ask that we strike the exhibits that she attached to her pretrial. They're not normally the kind of thing that get before the court unless they are admitted. But a lot of, as you know, a lot of people when they represent themselves are not clear on the distinction between offering an exhibit and filing it with the court.
Okay, and response from Ms. Lozano.
What I said, Your Honor, was I believe we should strike the pretrial because you didn't order it. To be honest, all you said was us to go ahead and file our retainer agreement and our bill, and then you did ask me to update my bill, which I did do subsequently, and then she was supposed to go through and do a line item, which she hasn't done. So I don't know what, I would strike it for a separate reason, Judge. One, you didn't order it, and two, it's irrelevant. I don't know exactly what it's there for, and then I know that you said it might impact the record, but I don't exactly see how it should impact us today, because one, you're going to retire, so you're not going to be able to hear it afterwards, and number two, very clearly, we were supposed to have this thing done months ago. I already have the lien adjudicated, done, already ordered, not set aside, already done, okay? What we're looking at, Judge, is the amount. There's nothing that allows us to not go forward today. I have a trial brief, which is I'm going to read into the record, that has nothing about anything that we discussed, okay? That's what's it's already been filed. Everybody has a copy of it. And then she has to stick to the point, and I know that's what you're going to do, Judge, is we got to stick to the point of why we're here today. So I'm sure, I know you worked with pro-pers before, but she's going to have to go ahead and stick to what we're talking about, which is any line item that's said before for all of the line items, because nothing has not been done. Okay, wouldn't do anything. So, the orders had to be followed, and this is outside the order, Judge.
Okay, move on. Mr. Rand. I want to hear if Mr. Grimes is in a position, otherwise I'll defer to move on.
And Your Honor, there's one other thing, that under our statute, too, if you remember, we're supposed to have this adjudicated within 5 days, so we're talking months that it's gone on, and it has nothing to do with the proceedings. It has to do with this bill.
Okay, Mr. Grimes, did your client take any position?
Your Honor, again, and we had kind of talked about this off the record, but I will put it on the record. My position is I have legally obtained these documents. They were not surreptitious. They were illegally obtained. I do not view them as overly relevant to custody, and I do not therefore see that I would be using them except to impeach. So they are disclosed. I would potentially use them to impeachment Lula at the time of trial if she testifies contrary to the contents of these documents. That's it. That's my position. Beyond that, I have no position of them being struck or anything else. They've been disclosed and I have them illegally. And so that would be, at this point, my position. Because that's my position, I've stated it, I believe I would have put everybody on notice if my position changed. But at this point, there's nothing that's changed in the last 8 months. It's not relevant to custody other than to impeach contrary testimony.
Thank you for your position. Okay, Luba, you're representing yourself in today's proceeding, so I will hear from you.
Thank you. So the kind of defense I am to raise does involve talking more about what we discussed between Don and I. So I would respectfully request to please do this after the custody case so it doesn't affect my custody case, which has already affected it.
Then And anything else from Mr. Gibbs or Ms. Lozano? Probably Ms. Lozano should go next, because if she would have to argue if there's any prejudice to waiting to do this after the trial.
And Your Honor, there is no prejudice. If you've already seen what she's already disclosed, everybody's seen what she's already disclosed. It has no bearing on the attorney's fees.
I just wanted to read one thing that Ms. Lozano said.
The big prejudice is I have not been paid, and we have continued to accrue more and more attorney's fees. This is ridiculous, Judge.
Okay, so I'll put down that you're concerned about interest blacking up pursuant to your, pursuant to your retainer agreement. It may not be interest at the legal rate.
Correct, Your Honor, but we have no amount, so I don't even know how to actually submit a judgment with an amount that's got assessment because we have no amount.
So you're not talking about prime plus 2%, the legal rate. You're talking about what the percentage is stated in the retainer.
Yeah, I understand that, Judge, but what I'm saying is us going forward today doesn't do anything to prejudice her. All it does is gives her the advantage of not having to pay. And you've given her months to not have to pay. So she's got an advantage already. She needs to go ahead and start paying for services she already rendered. That have been rendered to her.
There is a point that Ms. Lozano is not mentioning, and that is she's suggesting that because you hear this today, you're not going to be the judge at the trial of the divorce. That means there's no prejudice to Luba. As you indicated at the outset of these proceedings, this tape will be available to opposing counsel to study not just the exhibits that he already has, but the follow-up questions and cross-examination and how it's developed, and get inside the mindset that went into the preparation of my client's case with Ms. Lozano. So there is a prejudice in proceeding forward, and you as the judge have to think of the bigger picture, not just this one single issue of the adjudication of this name. You have to consider all parties and the case as a whole, I think. And so I think it is prejudicial. I think you're wanting to have a fair opportunity to address these, and I think that she will be harmed if we proceed today.
All right. I'm going to rule court orders at this trial is postponed until after the divorce/custody trial. That's basically it. The court claims that based on hearing the arguments from all the various sides, it would be potentially prejudicial to the mom to testify about the issues of the attorney's lien judgment and anything she discussed with her attorney that may have to do with the custody case, and it could be potentially not that assume that on the run's part, but it could affect the custody case. And so as far as striking the document, looks like Ms. Lozano really didn't oppose it. The direct question from Ms. Gonzalez said, I don't care what you do with it, strike it if you want. So I'm going to order orders that based on Mom's request, the document is stricken. Now I think Ms. Lozano said, if it's stricken, it's really irrelevant. A lot of this thing she talks about, I'm going to strike it. Okay, so I'm going to, but
I wasn't opposed to that, Judge. I thought it should be stricken because you did not order it.
I'm just going to strike it for whatever reason. Mom requested it. You did not oppose.
Did not oppose that. That's correct.
And neither did Attorney Gonzalez. But I'm going to tell everybody here, Attorney Gonzalez has a copy of what you filed. We'll strike it and take it out of the file but we have a copy of it, what it's going to impact, if anything, if it is going to impact on that. Mr. Gibbs will probably have to explain to you, give you the appropriate legal advice. Mr. Glenn said he'd use it to see if there was any kind of credibility issues, or if you said one thing, but you wrote something in this piece of paper that we're going to strike. And so, does that make you a credible person? But if you're not worried about that, and you're going to be consistent with your testimony, then you're going to really see what you testify to. But you finished the divorce custody trial. Court notes both sides previously stipulated to have trial in person in 2021. Correct? Right. Okay.
That's fine.
Since you
I wasn't part of that stipulation, as you know.
yeah, so I was waiting for her to do the order. No, officially, Gibbs isn't really right on this part of the case. Somebody's got to do the order. I don't even if the court has to do the order, so I'll have Lou to do it. Okay. So, yeah, you can follow the order instructions pursuant to the court minutes, and you can go to the Self-Help Center website, Luba, and shall prepare today's order since nobody's volunteering, but that's fine. And they want to say please. Shall prepare today's order. Yes, and Ms. Lozano, you want to sign off?
Your Honor, it would be easier, I believe, for me to prepare today unless we were volunteers. If you want me to do it, I can do it, Judge, because I know we can get it done.
Attorney Lozano shall do the order, and Mom, you want to sign off? I would like to prepare.
If you want to do it, that's fine. I was just volunteering.
Well, I figured you didn't want to because you didn't want to pay any more fees, so I can let Mom do it. She's good with computers. So if Mom
So if she wants to do it, that's fine. Just, I'll sign off. If it comports with the minutes, I'll sign off.
Okay, Mr. Grimes, Mr. Good, you don't need to sign off on this order for today. It's pretty straightforward. Just download the chat for your records. Everybody download the chat. We shall sign off and review. Okay. Alright. Confirm the trial date, Jeffrey Ann. Confirm the trial date for next year again. I'll put it in the chat box. You have it?
February 1st.
February 1st and 2nd?
Yes.
February 1st and 2nd, 2 full days at 9 a.m.?
Yes, absolutely.
February 1 and 2, 2021 at 9 a.m. start time. Did I tell you guys to call them that they're going to rearrange all the cases at the end of December is the best time to call the judge and confirm your firm? Your stack 1 is confirmed, but with new judge, possible assignment of dates nearby. Okay. Then you can go to the judge at the end of December and like, look on, we want to unfinished files, your priority. Is your judge going to keep it on the calendar or are you going to get it somewhere nearby? Because they're going to rearrange their calendar. Okay, so just the end of December, you should find out with your new judge. Okay, not subject to any peremptory challenges and all that, et cetera, et cetera. Okay? Thank you, everyone. Have a good day. Thank you, Jeffrey.
How to get back on calendar. You didn't tell us how to get back on calendar. We have to make sure it's very clear for her.
Well, it makes sense if they're going in February and they intend to finish in February. Do you want like a for sure date in March? And I can...
Absolutely, Judge. Absolutely, Judge.
When is Bishop? I know you guys go to Bishop conference. So you want third week of March on?
That sounds great, Judge. It gives everybody enough time.
Jeffrey and Cheryl, give me third week of March. Give me a date. We're stacking now, so but let me see if I have a stack one. Probably none.
You don't have any.
But maybe I can override it. Anyway, it'll be rearranged with the new judge. So third week of March will put us into March 22nd. Do I have a, and you guys are just a stack one half a day. That's all you need, is a half a day.
We need 2 hours, Judge. Not half a day. 2 hours. Not half a day.
Oh, yeah. Yeah, 1/3. Jeffrey, how about March 29th? Oh, no, there's a trial there. My bad. There's a 4-day trial there.
We only have 2 hours, Judge.
Yeah, but there's like an all-week trial there. I know. Trying to find a half day is the issue.
Well, we don't need a half day. Do you have an hour?
I have to use a morning. there's something weird. There's all for, April 6th looks wide open. I don't know why it's a Tuesday. You can have 1:30 till 3:30 if you want. Jacqueline, double check that date. Can you confirm with me about one, please?
That day is wide open, Judge, and they can have 1:30 to whatever time they're requesting, and that would be on Tuesday, April 6th.
So 1:30 to 3:30 on April 6th?
That's correct, Counsel.
Thank you.
Well, no, you can have until close of business, 5, whatever, you're not closing or whatever. 1:30. I told you guys last time you got 2 hours apiece.
Your Honor, you said it was an hour apiece.
1 hour apiece? Did I say that?
Yes.
Okay. 1 hour apiece, so it should actually finish 1:30, 2:30, 3:30, and 4 p.m. You know, estimated. DEA shall file a new amended order setting file and serve electronically. And I know that when she serves, Mr. Goodman, for all attorneys and moms. Okay, so
I would like to make sure that we're getting served because we haven't been getting served yet. So, because we've been looking. So I want to make sure for some reason we're not getting served.
okay, well, you're already served.
I know, but
Hey, Discovery is closed.
yeah, but because we're not a party, I guess we're not getting served. We're not supposed to have that other part of it at all.
You're a party in this trial, Ms. Lozano.
Correct.
Yeah. Now, Discovery is closed.
Correct, Judge.
Meaning, don't be asking for more Discovery. Don't be bringing more stuff. This case is just basically going to sit. Okay? Discovery is closed. That's it. But your trial exhibits, we're not even having trial exhibits from you guys. So,
We've already done it. It was the retainer, it was the bill, and then you asked us to supplement the bill, and you said this is about the extent of the exhibits, and we've already done that. And I've loaded them and everything to the court file. It's already done.
that's pretty much it. Okay. Just the billing statements and the retainer.
Correct. And then you asked us to supplement it with the second one.
Okay. Yeah, for the 2020 work, the lien work.
Correct, Judge. And we did that, and we filed a trial brief for today.
For 2020, for lien issues. Okay. Well, yeah. There you go. All right. Folks, that's it. There's really no trial now, folks. All right, thank you, everyone. Have a good day.
Thank you. Stay safe, everyone.
Thank you. Bye-bye.
How the fuck did I know that was going to happen today? This is ridiculous.